the Attorney General's office. I'm actually the hearing officer today. I'd like to ask the board members to identify themselves on the record so that it's clear we have a quorum.
James Simmons, right here. Howard Miller.
Colleen Jacobs.
Greg Orwell.
Thank you. Let the record reflect that Justice Franklin is also here. However, she was recused initially in this matter, so she will remain recused. The purpose of this meeting today is to revisit your September 27th or 22nd, whatever your September meeting was, wherein you considered the Robert Burns case. Mr. Burns requested that the deliberations be made in public, so I'm going to ask that you do that today, and then we'll go from there. Mr. Burns is asked to make a statement to you all, so I'd like him to do that first, and then if Mr. Bankston, Mrs. Hannah, has recused herself in this matter, if he'd like to, Mr. Bankston would like to make a statement, I'll let him do that. So I'm not going to have questions from Mr. Burns and Mr. Bankston. I'm just going to let them make a statement, and then you all can do your deliberations in open.
Thank you, and I appreciate the opportunity to make this opening statement. Let me first of all say that I am not going to be agreeing to sworn in for any part of this, nor will I take part in anything that is done here today. From my vantage point, this is a complete farce. It is no different than having walked out of a department store with merchandise and then be caught at the car and he said, hey, you stole this, and oh, it's no problem, I'll go put it back. No, the time to have made that decision about whether or not to walk out of that store with the merchandise was when you were into the four walls of the department store. Once you're out with it, it's too late, even if you are willing to go back. I know this is an attempt to put the genie back in the bottle, and I'm going to correct one thing. It was not a request. If you read the statute, it says I may require. Well, it makes nothing of your love, not addressing individually. Strike that. I know the letter I received said at your request. It was not a request. And Mr. Plainview made it abundantly clear he has the right to have it heard in an open meeting. I was requiring that it be done at the September 17th meeting. Unfortunately, the board chose to ignore my attorney's admonition and go on into executive session anyway. So I know the purpose of what you're doing here is a last-ditch effort to put the genie back in the bottle. It is a farce. I will take a seat and I will film whatever you have to say, but I most certainly am not going to be sworn in, and I most certainly am not going to partake in one iota of anything that happens here today. Thank you, Ms. Hunter.
As the board recalls, as a result of questions being raised to the hearing officer, where the hearing officer at that particular time made a decision that the deliberation should be conducted in executive session, and it so advised the board, and the board and the decision by the hearing officer was in fact to do that. Whether that is correct or not is a question in the law at this particular time, but in order to correct or comply completely with that issue, the recommendation has been that the board reinstitute or reopen the hearing in this particular matter that was set on September 17, 2012 for the purpose of deliberation in public concerning the factual aspects of the case and or whether or not it would like to take any particular action one way or the other. And for that reason, that's the purpose of why we're here today.
Okay, so I'd ask you all to allow charges that were filed against Mr. Burns.
I don't have a rebuttal, but I did forget one thing. Can I just briefly, will not take more than 20 seconds?
Sure. Be thorough here.
The other thing that I'd like to point out is that and the date was September 17th, just to get it clearly into the record. The other thing that I'd like to point out is that on September 17th, we were playing with real money. I had a license then. I'm sure most of you know now I am no longer licensed. So we're now playing with monopoly money. So to equate whatever decision may be made today or whatever deliberations you may have today with those that took place on September 17, 2012 are not compatible. I'll apologize, I meant to remember that earlier.
Okay. Does anyone have any comments, discussion you'll recall?
I have some discussion. As I stated in the previous meeting, I don't think that the conduct would warrant taking of that reason, I voted no.
Okay. Does anyone else have any comment about Mr. Burns' case? Can you explain why you chose to give him a public reprimand?
We decided in executive session that the board would publicly recommend that we give a license.
Can't hear us.
Elevate the volume.
We didn't feel that there was just cause for the license. We approved the statutes for the record regard, which each might record.
That's good.
So, we decided that the board would do a public recommend rather than just a public license.
Suspension and fines was discussed, but this public recommend was kind of a better way to handle the situation. We kind of discussed back and forth which way we should go. There was sort of point counterpoint on different feelings and thoughts about that. But in the end, we came up with a public reprimand, and I felt as it not being any fine, not taking his license was going to be a very positive thing. We could work in a very positive light to make sure that we kind of had an olive branch out there to work with Mr. Burns in the future. So just a reprimand, as far as the
If there's no other comments, it would be appropriate for the board to take whatever action it would like to.
Well, at this point, as I stated before, I do not feel that his conduct warranted the taking of his license. But as we had discussed at the prior meeting, we did feel that a public reprimand was in order. And I believe we also discussed that Mr. Burns, instead of not making the harassing comments that he has made in the past towards members of the committee and employees of this committee.
So you remain of the same opinion, you would reaffirm?
I'm of the same opinion. I would vote not to take his license. I would vote for the public reprimand.
Any other comments?
I can't comment based on my attorney's, my personal attorney's advice. Because I didn't vote to reprimand him. I thought we should have went further.
Okay, so I think it'd be appropriate for an actual formal motion.
I'd like to make a motion, first of all, that we amend the charges to vote not to take his license, but to go forward and give him a public reprimand.
To reaffirm what you did in September?
Exactly.
Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed?
No,
You opposed?
I oppose.
Motion carries by majority. That's really all we have for this matter. I'm not aware of any other adjudicatory hearings on the agenda. Are there any other hearings?
No.
Okay, no other hearings, then we will adjourn. Thank you very much.